Hello and welcome to this sixth presentation all about trusts. In this presentation, we will be covering a few different areas, which will include the defenses available to trustees who may have claims of breach of trust against them. We will talk about the ownership of property in the context of insolvency. We will talk a little bit more about strangers to a trust, so going into more detail from the last presentation where we briefly talked about the idea of a trustee de son tort, and we will round things off by comparing trusts to other legal structures. So let's get into it. In the last presentation, we discussed how breaches of trust can cause a trustee to become personally liable for any loss or harm to the beneficiaries. And we also talked about who can actually claim against the trustee and the sort of remedies that they can actually claim for. But there's something else to be added to this, and that is that there's actually some defenses that trustees can use, which will mean that a breach does not actually result in personal liability. I know you're curious to know more, so let's explore this now. The first defense is consent from the beneficiaries. So this defense first concerns itself with the beneficiaries themselves. For the beneficiaries to provide any consent in the context of a breach, they must be 1, of legal age, 2, they must have capacity, so they must be sound of mind, 3, they must be fully informed of the breach and the effects of it, and lastly, 4, they must give freely informed consent to the breach that can actually be evidenced, so in writing ideally. This is because acquiescence is not enough. So agreement by not protesting against the breach is not considered a beneficiary's informed consent. So interestingly, if a trustee does something or fails to do something which would actually result in a breach of trust, but the trustee was actually able to get consent from all of the beneficiaries to allow that act, then actually the trustee may be excused from liability altogether. The next defense comes from the Trustee Act of 1925, specifically Section 61. In a situation where a trustee has acted honestly and reasonably, the court can actually rule that the trustee can be excused from liability if a breach has occurred. This is because the court actually has discretion, so the power to relieve a trustee from personal liability. This is not a relief that is just given out freely. It is reserved for specific situations. Examples of situations where this relief would be given would be, for example, where the trustee is a lay trustee, so they are less scrutinized compared to a professional trustee. Then you may have situations where the breach has a minor effect, and then you have situations where the trustee has actually sought professional advice, and then they relied on that advice, which then later led to a breach. It is important to note that this relief is only given to trustees who have actually acted honestly and reasonably. If a trustee has acted dishonestly or recklessly, then they can forget about this relief altogether. The next defense is found in the Limitation Act 1980, specifically Section 21. So this section states that for most breaches of trust, the time limit for a claim to be brought is 6 years, and that the 6-year time frame actually starts from the date of the breach itself. However, there are certain situations where the limitation period would not apply. So this is, for example, in situations where the trustee has committed a fraud, or they retained a legal title to trust property when they shouldn't have, or they have benefited personally from the breach itself. So if any of these apply, then there is no limitation at all, and a claim can be brought forward at any time. The fourth defense is the defense of an exoneration clause. Sometimes a trust deed may actually include a clause, so a section, which will explicitly exclude or limit the liability of a trustee. These types of clauses are referred to as exoneration clauses, indemnity clauses, or trustee protection clauses. But they all essentially function in the same way, no matter what they're called. They all function to limit the responsibility of a trustee in the event of a breach. However, these clauses may protect the trustee from liability regarding, for example, negligence or minor mistakes in good faith, but they will never protect the trustee against fraud, dishonesty, or willful default. This is something they will not be able to escape liability from. And the last defense is the defense of reimbursement and indemnity. So when a trustee is actually found to be liable, whether fully or only partially, they can rely on 2 points to limit their overall personal loss. These are that the trustee has a primary right to be reimbursed for any expense that they have incurred whilst acting for the trust, and the other is that they can be indemnified, so held harmless and then compensated for loss, for any liability or cost that they have actually incurred reasonably as a result of acting for the trust. So these 2 points apply if the trust deed has specifically mentioned them in a clause or a provision, or they can be implied by law, so by operation of law, when the trustee has acted in good faith and in accordance with their duties throughout. So these points do not excuse the breach at all. The aim here is to limit the overall loss that the trustee will face personally, so they aren't placed into a situation of hardship unnecessarily. So we've covered the defenses a trustee has. Now let's move on to the ownership of property and how this relates to insolvency or bankruptcy. As you will be aware by now, a trustee holds assets on trust for the benefit of someone else called a beneficiary. The trustee will hold the legal title, which will have to be in their own legal personality name. However, as the trustee is holding this property for someone else, this property is not actually part of the trustee's personal estate. It is simply not their property. All they are doing is holding the legal title to it for someone else. This becomes particularly interesting in situations regarding insolvency or bankruptcy. So now let's focus a bit on the separation between trust property from the personal assets of a party to the trust, and explore what actually happens if one of these parties becomes insolvent or bankrupted, and also how trust can actually be pierced by creditors. First up, the trustee's estate. So when I talk about the trustee's estate, I mean the trustee's personal estate, so the property that they own themselves. It is key to know that the trust property is not part of the trustee's personal estate at all. As you know, the trustee is just holding the legal title to the trust property in a fiduciary capacity, so for the best interests of the beneficiary. So that means the property is not their property outrightly, nor could they attempt to claim this. Therefore, if a trustee was made insolvent or bankrupt, then the trust property is actually protected from the trustee's creditors. These creditors wouldn't be able to take the trust property to settle any of the debts of the trustee. The creditors could only attempt to take the trustee's personal assets to try to settle the trustee's personal debts. Now imagine you have a settlor who has become insolvent. If a settlor has become insolvent, so they're unable to pay their debts, but they have actually already transferred their assets into a valid trust before the insolvency, then these assets will be protected from creditors, simply because those assets do not make up the personal estate of the settlor anymore. They are trust assets now. This will be true unless the settlor has actually transferred property in an attempt to defraud creditors, so misleading the creditors to prevent them from being able to receive something that they would otherwise be entitled to because they are owed something. It will also be true unless the trust is considered a sham, which essentially means that there is a trust that has been created, it appears valid and legit from the outside, but when you begin to dig a little bit deeper, you quickly realize that actually the parties to the trust never intended for a trust to be created. They just wanted it to look that way in an attempt to get away from liabilities, for example. And it would also be true unless the settlor has actually retained some sort of control or benefit to the property that has been put into the trust, especially if they retain either the legal or equitable title 100%, and they don't have any other trustees with them or any other beneficiaries. In cases where something has been done involving a trust, but the true intention or the purpose for that trust being set up in the first place was actually to defraud creditors, then the Insolvency Act of 1986, specifically Section 423, may be applied in court proceedings. So this is where the court will have the power to set aside the trust completely or reverse the transfer of titles to the property. So in other words, they cause the trust to be unwound completely so the assets go back to the settlor and the creditors will be able to come along and get what they were owed and maybe even more as they were being defrauded in the first place. There's a key case that actually demonstrates this really well, and that is the case of Midland Bank v. Wyatt in 1995. The facts of this case were that Mr. Wyatt declared a trust of the family home, and he stated that he held the family home for himself and for his wife in equal shares, so they were both beneficiaries. So we can see from this, he declared the trust as the settlor, he then accepted the legal title, making him trustee, but he also took beneficial title in equal shares for himself and his wife, so a 50-50 split. However, remember the saying that actions speak louder than words? Yeah, well, this is a good example of that because Wyatt never actually acted on the declaration at all. In fact, he even hid it from a bank when he was attempting to secure a loan. So, on paper, there was a valid trust, but based on his actions, he acted as if the home was just his, showing that he really never truly intended for the trust to actually apply in real life. The court therefore held that the trust was a sham, simply created to protect the property from creditors, as there was no real evidence that there was a genuine intention to create the trust and actually have his wife as a beneficial owner alongside Mr. Wyatt. This case shows us that trusts can be declared invalid and treated as if they never existed anyway, if evidence arises that the parties never actually intended for the trust to have legal effect. This shows us really clearly that for a trust to truly be valid, not only must it be formally declared, but it also needs to be genuinely intended and treated as real in practice. Moving on to the beneficiary. So if a beneficiary is declared insolvent, then actually their equitable interest to trust property may become available to creditors, which isn't ideal, especially if someone has settled a trust to specifically protect beneficiaries who they know are likely to get into financial difficulties. However, there are a few ways to get around this if a settlor is attempting to protect a beneficiary that they know is likely to run into financial problems. So these include making a discretionary trust, where the beneficiary has no absolute entitlement to the trust property or the trust fund. If you recall from the third presentation on trusts, we covered discretionary trusts in that presentation. In these types of trusts, we know that the trustee actually has discretion to decide who will benefit, when they will benefit, how much they will benefit, and so on. Well, this is perfect to protect a beneficiary who may not be able to handle their finances very well, because the trustee can actually exercise their discretion or their powers and can therefore evaluate the beneficiary's circumstances to see if it would actually be a good idea or not to make disbursements to that beneficiary. So they will be able to see that, obviously, if the beneficiary is going through an insolvency, well, a trustee of a discretionary trust can use this information to come to the conclusion that that specific beneficiary will not have a right to disbursements. And therefore, these disbursements couldn't become part of the beneficiary's personal estate, which would then be used to settle debts with a creditor. The other way is for a settlor to include a protective clause in the trust deed itself, which would allow for the trustee to withhold property to an otherwise entitled beneficiary under specific circumstances, which, of course, the insolvency of a beneficiary would fall into a specific circumstance. It is important to note that if a beneficiary has a fixed interest, so it cannot be withheld from them, for example, so they're entitled to, let's say, 75% of the trust fund, and that this cannot be withheld from them, for example, then this may actually be seized by creditors, or the interest could actually be assigned to a trustee in bankruptcy. So knowing this information is super important if someone is looking to settle a trust for a beneficiary who they know may be at risk, especially if the settlor is settling a trust with the goal of having a trust support generations to come. Now, let's imagine the trustee is actually a company. If the company is facing insolvency, then there are a few key things that will apply here. First, the insolvency of the trustee company does not affect the trust that they are trustee to in any way at all. Second, the trust property is still subject to the trust and also to the fiduciary duties of the trustee company. So this will still apply as if nothing has happened. Third, a new trustee or administrator will have to be appointed to continue with the management of the trust assets. And of course, if the trustee company has been managing the trust well, then this transition should not really affect the trust nor the beneficiaries too much. The impact will hopefully be minimal. However, problems may arise if the management hasn't been as well managed as it should be. Say, for example, the company assets, so the assets that belong to the trustee company itself, and then the trust assets, so the assets that are subject to the trust. If these two have been commingled in any way, so if they have been mixed up, or if there has been a lack of proper accounting or records, or if the trust was not even properly constituted in the first place, so the legal title to the property was never properly transferred to the trustee company, then all of these factors will actually make a transition a nightmare and will also cause all sorts of issues when trying to see what is the trust property and what is the trustee company's actual property. So all of these points teach us some very valuable and practical lessons here. First, they show us the importance of separating the trust assets from the personal or the business assets very clearly. It is therefore best practice to make sure that we have good records to show these distinctions really clearly. Secondly, it shows us the importance of creating trusts before you have problems, especially if bankruptcy is a process that someone is likely to face for whatever reason. Thirdly is record everything. This will include transactions made, meetings conducted, contracts entered into, all of it, so that everything has a proper paper trail. And lastly, use discretionary trusts to protect certain beneficiaries who may actually become insolvent later on down the line. Now on to sham trusts. These are really key to understand and to be able to identify quite clearly, because if you are making a trust or you're looking to make one, you want to do everything possible to avoid the claim of a trust being a sham. So a sham trust just refers to a trust that appears valid on paper, but in reality, it was never intended to actually have any sort of legal effect. Someone who makes a sham trust never intended for the trustee to actually have control, nor did they intend for the beneficiaries to have any genuine rights of enjoyment of the property that has been put into the trust. And as we discussed earlier, a trust that is held to actually be a sham can be set aside completely, with the assets being treated as belonging to the settlor, either because the trust was never validly created in the first place, or it's being held on resulting trust. A case that shows us what a sham document actually is comes from the case of Snook v London and West Riding Investments Limited in 1967, where it was actually said that a sham document is a document that intends to give the appearance of legal rights and obligations, which are actually completely different from the actual agreement or the actual conduct of the parties to that sham document. So this applies to trust, right? But it could also apply to any legal document really, which is created to give the appearance of one thing, but in reality is something different. So some indicators of a sham trust includes 1. The settlor actually retains beneficial enjoyment, especially if they are the sole beneficiary. 2. The settlor manages the trust property or the income alone, so they are the sole trustee. 3. The trust documents are vague or they're inconsistent, backdated, or they've been tampered with, and stuff like this. 4. The trustee does not actually engage in independent decision making. So say for example, they are always running to the settlor to get help in making decisions. 5. The beneficiary or the beneficiaries are not actually aware that they are a beneficiary of a trust. 6. The beneficiary or beneficiaries do not know about the rights that they have, so which property they have rights to and which proportional share they have and so on. And lastly, 7. The trust terms are not actually being followed in practice. So it will be a combination of 2 or more of these indicators that will collectively evidence a trust as a sham. It can't just be one of these points by itself which will prove a trust is a sham. It will have to be various of these indicators working together at one time which will collectively evidence a sham trust. Now, I would like to run through the concept of strangers to the trust. What do I actually mean by this? Well, strangers to a trust simply refers to someone who is not a trustee, nor a beneficiary, nor a settlor of a trust. So this individual has absolutely no legal role or rights in relation to the trust. They are a complete outsider, basically. However, if a stranger to the trust begins to interfere with the trust itself, they can very quickly go from free of liability to being held personally liable, depending on what their interference actually consists of. A case that has allowed us to understand this in a better way is the case of Barnes v. Addy of 1874. This case showed that, generally speaking, strangers of a trust will not usually be held personally liable unless that individual has actually received and become chargeable with some part of the trust property, which is referred to as knowing receipt. So in other words, that individual has actually gotten trust property into their possession somehow, and they know that they are holding trust property when they shouldn't be. Or unless they assist with knowledge in a dishonest and fraudulent design on the part of the trustee, which is referred to as dishonest assistance. So in other words, they help trustees act in a deceitful way. So strangers to a trust can be ordered into 3 categories. You have 1, trustees de son tort. So the de son tort part, all this means is wrongful. So it's French for wrongful. So if you say trustee de son tort, you are essentially saying wrongful trustee. As we have discussed in a previous presentation, this refers to someone who is acting as a trustee, but they haven't actually been appointed as one. So they are essentially intermeddling with the trust property in some way. So they will actually be held as a constructive trustee, owing the same duties as if they had actually been appointed. So a quick side note here. So we know that de son tort literally just means wrongful, right? Then we can begin to see how this could also be informally applied to other positions in the trust. For example, settlor and beneficiary. There may be certain situations where someone is claiming to be a settlor or a beneficiary to a trust without actually being a settlor or a beneficiary, nor being able to prove their claim to these positions. And therefore, in effect, they would be acting as either a settlor or a beneficiary de son tort, despite these terms not being officially recognized. Moving on to 2, persons in knowing receipt. So this is just someone who has knowingly come into the possession of trust property in breach of trust trust, as we discussed in the previous slide. And lastly, there's 3, persons engaging in dishonest assistance. So someone who's assisting in the dishonest breach of trust conducted by a trustee. For example, they help a trustee in disbursing trust property to someone who's not actually a beneficiary. Now, let's spend some time comparing trusts to other legal concepts. Firstly, let's compare them to contracts. So the first thing to remember is that a trust does not have a legal personality of its own. It does not exist independently to the trustee, and actually it requires the trustee to have a legal personality themselves to be able to own property. So this therefore means the trust can't actually get into contracts just as it is, because it doesn't have a legal personality to actually be able to get into contractual agreements with other legal personalities. So it relies on the trustee getting into contracts in their own legal personality name or via their legal personality name on behalf of the trust. Then you have the express trusts arise from the unilateral declaration of the settlor, so the one-sided declaration. Whereas contracts typically are bilateral and multilateral, so they're between 2 parties or between more than 2 parties. And lastly, a trust does not require consideration to be valid. Contracts, however, they do have to have consideration or some sort of value which is exchanged between the parties, which is actually one of the key features that is required of a contract to actually make it valid and enforceable. Now let's compare trusts to bailment. So bailment refers to the process where someone is in possession of some property, but they do not have ownership rights over that property. So this is common when property is being loaned to someone, or someone is hiring that property, or maybe someone is storing property on behalf of someone else, or maybe someone has possession of property so that they're able to do some work on that property. Say for example, when you take your car to a garage for maintenance. This type of legal relationship can be voluntary, involuntary, or even as a reward that's governed by contracts. So in these relationships, the bailee, so the one who's in possession of the property of someone else, they will have a duty of care for that property, but they do not have an equitable duty or a fiduciary duty or anything like that because they never got legal title or any sort of ownership rights transferred to them. The last concept is executorship. So an executor is someone who owns property of a dead person. This is because dead people cannot own property. As you can imagine, when someone passes away, they don't take anything with them beyond the grave. So at the moment of death, the legal title to property will vest by operation of law to the executor of the will of the deceased. So in other words, the law imposes this role due to the triggering event of the death of someone and not because anyone actually intended for this to happen. Therefore, the executor will owe fiduciary duties, so they act in the best interests of the beneficiary or the beneficiaries of the will, but this doesn't automatically mean that they're considered to be a trustee just because of their role, unless, of course, the will itself actually did express a trust within its terms directly and called for that executor to be a trustee. So hopefully these few examples have demonstrated to you the key things that set trusts apart. The key features, I would say, are that trusts do not have their own legal personality, that they are a unilateral declaration, that they don't require consideration to be valid, and they actually transfer title or ownership of property to someone else. So let's just take a moment to glance over all the things that we have covered in this presentation. So we have covered the defenses available to trustees who have claims of breach of trust against them. We've looked at the ownership of property in the context of insolvency and bankruptcy. We've looked at what a sham trust is and how they can be identified. We've discussed strangers to a trust and how they are actually treated. And we've also compared trusts to other legal concepts. This brings us to the end of this 6th presentation all about trusts, and hopefully you are really getting a good understanding of what trusts are and you're really starting to feel like a proper trust warrior now. hopefully being able to identify all of the defenses that a trustee can have up their sleeve. You're also able to identify the best practices for trustees. You'll be able to recognize a sham trust when you see one. And you're also becoming really confident in what sets trusts apart from other legal arrangements. If you found value in this presentation, please leave a like to let me know, share it with someone else to spread the knowledge, and don't forget to subscribe for more law educational videos. Thank you so much for watching, and I'll see you in the next one. Adios!